Now back to the show. This is The Law Show on CL 650.
Do you swear to tell the truth and nothing but the truth, so cross your heart?
Yeah, The Law Show, CL 650. We're talking about immigration and citizenship law. We have Gordon Maynard and Alex Stojcevic from MKS Law in downtown Vancouver. Website super easy to remember, vancouverlaw.ca. Now, the Chamber of Commerce, in the last month, came out with a report talking about express entry. This is right up your alley. The problems that we talked about in the first half of the show, and you both mentioned the word skating beforehand. Now, Alex, give us a 30,000-foot level, and then, Gordon, I'll get you to read some of the report back, and people can hear exactly how the Chambers of Commerce across the country feel about this.
So the principal issue is that at first, this was actually quite a popular program. It was sold as something that would have a large employer component. And it was sold to employers as the idea that they would have a role in the selection of immigrants. And
filling their needs.
So from that sense, it was it seemed like it was going to be demand driven, and it was going to be responsive to economic demands of companies. And it also left the sense that they had a meaningful role to play in all of this. And so when it was rolled out, they were originally one of the large supporters of this program. And the
government at the time, which was the conservative government, yeah,
which was generally speaking quite friendly to the Canadian Chambers of Commerce by and large. Now, the report talks about the promises of the system and its advantages, and then the missteps in its implementation. And one of the first missteps they talk about is that close to 2 years prior to the launch of the program in January of 2015, the government consulted heavily with business organizations, employer organizations, labor organizations, all the stakeholders in the foreign worker issues, as well as in immigration generally. They also went to their own policy experts. They went to the Centers of Canadian Immigration Excellence in various institutions across Canada, and they predicated and developed, allegedly with everybody's consultation, this express entry. And then after overhauling the temporary foreign worker program in 2014, they essentially undermined this whole process of stakeholder involvement, of building up this kind of fast, responsive system by converging supply and demand through express entry, is the phrase they use, by putting in this labor market impact assessment requirement.
So that's the fly in the ointment.
That's the fly in the ointment, and that is most of their complaint about the system as it was rolled out.
So read us some of the report, Gordon, and what they have to say.
This is from page 4 of the report. In the global competition for highly skilled talent, the government sought to improve the economic immigration system with the launch of Express Entry Application Management System in January 2015. Yet, in an atmosphere of hyper-political reaction over temporary foreign workers, the government made policy choices that ultimately sacrificed the efficiency of the express entry. The situation has become untenable and dismaying. The actual design of the system has had negative effects across high-value growth sectors, from high-tech to financial services to academic research. Policy approaches that were born of suspicion, negativity, and reprisal were applied to the temporary foreign worker program, and then similarly and inappropriately applied to express entry. For all the good work of government officials, the programs are falling short of their goals and creating inefficiencies within the department.
You look at what some of the criticisms are from industry. They're all actually put together really well here. They quote numerous counsel who don't do what we do, who aren't about immigration solutions, but are looking at the compliance on the part of the employer.
Mm-hmm.
And what they're telling their clients, if they're
so these are the HR people, right?
The HR and the corporate people. They're saying, we don't want you to hire any foreign workers because the compliance is too onerous,
mm-hmm.
and what is being asked of us is too much. So I think it's risky. Don't do this. Okay. You have others who are saying that the LMIA requirement as a tool to be put into permanent residence selection is very ill-suited because it's really designed to protect certain labor markets. It doesn't really look at what people are bringing to the table.
Mm-hmm.
And this reverberates everywhere. It's caused a chill in employers looking to recruit foreign talent, and it's, in that sense, been exactly the opposite of what the government has wanted.
Is it as easy as getting rid of the LMIA portion of the test,
Yes.
and that would solve the problem?
No, they shouldn't restrict the bonus points to just LMIA work permits. They should recognize that intercompany transferees, whether they're NAFTA or our regular regulatory provisions, that they should also qualify for selection based on their employment in Canada and offer of employment. And they should also give points to students who have progressed through studies in Canada, to postgrad work permits, to continuing employment for a year and an offer of permanent employment. Those people need to be selected. Now, keep in mind something here. For 2015, we're still going to hit our numbers. We're still going to hit 185,000 economic immigrants, even with, or 167,000.
Even with all of these roadblocks?
Even with these roadblocks, but that is because we're still living off the applications that were processed prior to express entry. So express entry hasn't come home to roost yet. The problems that we see, and which the Chamber of Commerce sees in express entry, are going to become more and more impactful over the course of the next 2 years.
And part of the concern that industries had is that this is an automated system. So it's great in the sense that processing now doesn't involve paper, it's quicker, etc. But what is not helpful is that you're dependent entirely on how much the government has invested in the technology.
Now that's your point earlier in the show, is we're going to get rid of all these people and replace them with computers, but they got rid of them maybe too quickly, the people.
Let me give you an example, a real-world example of a case I had to deal with yesterday. I spoke to a woman who is a corporate counsel in-house for a company in Rijeka in Croatia. She applied for permanent residence. She did it all by herself. She looked online, and one of the things she discovered is that if she applied through express entry, she had a lot of points. I mentioned earlier you had to be the right age, you had to have a master's degree, and your English was perfect. Well, she had all of that.
Sure.
So she qualified at 455 points. Now, her problem is that she's in her second relationship. She has a child from a first relationship. And as a requirement of Canadian immigration, she required the spouse or ex-spouse's agreement for this child to come along. That spouse refused to do that. So she had to start a court case in Croatia. So for that reason, she applied on her own and declared all of her current spouse and her other children as non-accompanying dependents, had them medically examined, had them produce police certificates, and she said, later they will come to Canada. Right now, I will sponsor them, but right now they can't because of this outstanding custody issue. She's selected with 455 points. And what happens then is she somehow wins her court case. She's surprised as much as anybody.
So now she can bring her child.
She can bring her children, she can bring her spouse, so she adds them all in there. The computer now no longer treats her as somebody who is single. So her point index changes and she loses 19 points because she hasn't had her husband go do a language test, hasn't done anything else. The system now has withdrawn her invitation and wants to refuse her for permanent residence. For what? For what good possible reason can you take this woman who's meanwhile now bought tickets, arranged her affairs, put her house up for sale? Now she's being told she can't immigrate because of a situation that didn't exist when she was invited, but exists now, and absurdly somehow because she has 6 less points, she shouldn't be allowed to come. And this is one of the things that is complained about in the system, is that there's absolutely no common sense anymore in it.
So that's where a human would look at it.
Exactly.
Instead of a computer and say, well, we can work with you on this. And did that happen in the past? Could you work with the federal government?
Absolutely, because there were humans you could talk to. There are
was
fewer of them now.
There was actually a visa office with a visa officer who was responsible for a file. There was actually a phone line that could be used to contact officers at offices in Vancouver, whether they were economic services or CIC. Nowadays, everybody's behind walls. Phone numbers are not given out. It's not a publicly accessible service. What they do give out is a public helpline number, which sometimes can be useful when you get through to it, but many times you're dealing with an officer or
you just put on hold. Yeah.
Average wait time 45 minutes.
Yeah. Well, what's interesting is because the banks went through this years ago, where they automated everything, and then they've realized that no, it's the personal touch that gets. But that's a competitive business. TD Bank competes with Scotiabank and all of the other ones. Government doesn't have any competition.
Yeah.
Well, except that it does, right?
And that's another country.
And that's another country. This is supposed to be about a highly skilled international talent, and that's why the report is called Highly Skilled International Talent at Risk. Instead of making a system that's easier to bring international talent, you've created all kinds of uncertainty, where international talent is beginning to believe that Canada is not available for them to immigrate to. And that's exactly the wrong message that the Canadian Chamber of Commerce was hoping that this program would send. And certainly the title of it, Express Entry, it means you get to come fast, right? And in reality, it means you don't get to come at all.
There's so many ironies in all of this. I mean, the Express Entry system was heavily touted by the government before it was put in place. And people were told around the world through the internet that you're going to get immigration in 6 months. We're opening it up. We're taking away the restrictive occupation list. It all looked great. When people try and use the system and find out that you need an LMIA, it's the employer's responsibility to get the LMIA, and they are bludgeoning the employer with a very difficult process.
And do you deal with employers on that?
Oh, all the time.
That's
all the time. And it's
And are you hearing from them that they're losing people, that the applicants?
well, they're losing applications to Service Canada. I mean, the dialogue that goes on between the employer and Service Canada and the application is appalling. Here's what the Canadian Chamber says about it. They say Canadian Chamber members report that the LMI process to support temporary workers is almost unusable for most employers, especially small businesses. And we can tell you from experience.
Well, why don't we talk about it after the break, because we have one final segment to go on. Express Entry, which isn't so express. The study exposed 1 year later. That's the theme of this week's show. We have Gordon Maynard and Alex Stojcevic from MKS Law in downtown Vancouver, specialists in this whole field, when we return next on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.